All right, we are streaming, right?
Yes,
Shubhamji?
ma'am, we are live.
All right. Good evening, everyone, and good morning, Mr. Kaplan. And thank you so much for joining us. This session of the joint HKIAC and CADR JGLS webinars is a topic that a lot of us have been hearing about a lot. We also have been reading about it a lot. We talk about it as a paranoia, and that's what a lot of academic articles got written about as the due process paranoia. However, we have with us the best person to discuss due process concerns in relation to virtual hearings and some other ideas, that is Mr. Neil Kaplan. I'm going to take a quick minute to introduce our speaker to our audience today for the uninitiated. Mr. Kaplan is fondly referred to as the father of Hong Kong arbitration and was called to the bar of England and Wales in 1965. Mr. Kaplan has practiced as a barrister, principal Crown Counsel at the Hong Kong Attorney General Chambers, and served as a judge of the Supreme Court of Hong Kong in charge of the construction and arbitration list. From 1991 to 2004, he was chairperson of the HKIAC, and from 1999 to 2000, he was president of the CIR. Since 1995, he has been a council member and now governing board member of the International Council of Commercial Arbitration, which is the ICCA. And in 2012, he became a member of the ICC International Court of Arbitration. He's a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators, the Hong Kong Institute of Arbitrators, and the Singapore Institute of Arbitrators. He's a panelist of several other arbitral institutions, including the CIATAC. Those of us who've been learners and researchers and instructors in arbitration for a while have read a lot of awards from panels where Mr. Kaplan has been a part. In fact, as a personal anecdote, when I was studying my master's at NUS, Mr. Kaplan's work on the law applicable to the arbitration agreement through his awards was something that I relied on heavily because the HKIAC was doing a lot of awards at that time, and I was working with an arbitrator at the CIAC at that time. So even though I've never interacted with Mr. Kaplan in the past, I feel that there is this one academic connection of sorts that I do have. And it's my privilege to have you with us today. Mr. Kaplan, please, the floor is yours. Thank you so much. And to everybody, at the cost of being repetitive, please try and keep your cameras on. Thank you so much.
Well, thank you very much for that introduction. And I'm very pleased to be with you in this virtual fashion, which we've become very used to over the last 18 months or so. I spend my whole life on Zoom, so I call myself a Zoombie. And it's pretty good, but we'll see that there are some problems. But let's start off by defining the topic that we're discussing. Now, due process may be hard to define, but it's easier to appreciate when it's being denied. Unfortunately, due process allegations against tribunals have increased over the years because now that the appeal on the merits of an award have in fact been cut off mostly, the remaining challenges are to the award, are mostly against the process or against the arbitrator. And this is what's led to the phrase due process paranoia, which is a state of mind on the part of the arbitrators to do everything they can to avoid being criticized or having their award set aside by a supervisory court. Some parties use due process paranoia for their own advantage. Lucy Reed, who is the currently president of ICCA, pointed out in a recent article entitled Abuse of Due Process, Sword Against Shield, that some parties deliberately, with premeditation, use due process as a sword, a strategic sword, to attack other parties in an attempt to influence the tribunal. In her words, quote, "The strategy, not a subtle one, is to take routine procedural objections and elevate them to due process challenges by label, by repetition, by amplification, by sheer number, and by unrelenting tone." And I can confirm that that is not an unfair description of what does happen from time to time. It's either done in an attempt to intimidate the tribunal with a message that the award might not be enforceable, or to gain an advantage over the other party by making so many unreasonable applications that the tribunal becomes more likely to grant some percentage of them. Yet another goal is sheer delay. Tribunals are frequently in receipt of correspondence and submissions that threaten that if the submission is not accepted, then that party's due process rights will be infringed. Tribunals do not like these threats because they are well aware of the party's rights and do their very best to respect them. But that is not the same as saying that every position advanced by a party has to be accepted. And if it's not, due process rights will be infringed. Now, the importance of due process is underscored by the terms of Article 5 of the New York Convention, which provides that one of the few grounds of opposition to enforcement, as you know, is that a party has been unable to present its case. Now, frequently, a tribunal will unknowingly or by accident prevent a party from presenting its case. There are many examples in the books about this, but do forgive me for telling you about one of the few cases that I heard when I was a judge in Hong Kong, where I refused enforcement under Article 5 of the New York Convention, which explains the point I'm making quite neatly. In this case, Chinese buyers bought some steel coils from German sellers, and the risk passed to the Chinese buyers when the steel went over the ship's rail at a Turkish port. The goods landed in northern China and were sent by road to southern China, which, as you know, is subtropical. They were left out in the open for some time, and when sued for the price, the Chinese buyers claimed that the steel was rusty. The German sellers said that it was clearly not rusty when the risk passed in Turkey. At the end of the hearing before three CTAC arbitrators in China, of course, I think in Beijing, they decided that it might be a good idea to have the steel inspected by experts appointed by the tribunal. The German sellers said that that would not be a good idea because there was probably little doubt that after being left in the open for months in subtropical conditions, the steel may well be rusty, but that wasn't the issue. The issue was whether it was rusty when the risk passed in Turkey. But the tribunal insisted, as they were entitled to do, on appointing experts, and the German sellers asked if they could be given a copy of the report when it was at hand. When the report was produced, it concluded by a somewhat strange methodology that because the steel was rusty when they inspected it recently, it must have been rusty when months before it boarded the ship in Turkey. The German sellers were somewhat surprised by this and immediately wrote to the tribunal and asked that they be given an opportunity to cross-examine the experts, again, as they were entitled to do. But unfortunately, that letter crossed with a copy of the award in favor of the Chinese buyers. The award was then brought to me in Hong Kong for enforcement under the convention, and after considerable argument, I decided that the German sellers had not been given an opportunity of presenting their case on this issue, or whether or not the fact that the steel was rusty when inspected meant it was rusty when it was handed over to the other side in Turkey. It was clear to me that they had had no opportunity of dealing with this case, and the tribunal should have given them the opportunity of cross-examining the experts, or at least being heard on this new argument. Now, I'll refer to some other cases more recently in a minute, but this leads to an important point, namely, how much opportunity to present its case is enough to outweigh the bare minimum requirement of due process. Should it be a bare reasonable opportunity, or should it be broadly interpreted as a full opportunity? Now, as you know, the New York Convention was done in New York in 1958. The take-up was slow. It took 20 years roughly for the United States and the United Kingdom to adopt the convention. But as we got into the 80s, things started to change, and many more countries ratified the convention. And today, I think you could say that almost every major commercial center jurisdiction has adopted the convention. I can't remember, it's 170 jurisdictions, 180, whatever it is. But you must draw a distinction between jurisdictions and territories, because, for instance, Hong Kong would not be a country, but it's a jurisdiction. So you won't see Hong Kong on the list, you'll see China. And for instance, in England, you'll see United Kingdom, but you won't see, you have to add in the dependent territories like the Bahamas and other places. And so the number is much higher than the number of states. In 1985, the General Assembly of the United Nations recommended the model law, and I don't need to remind you of the enormous influence the model law has had around the world. Many states have adopted it, some have adapted it with revisions, and some have simply amended their arbitration laws to reflect the basic concepts of the model law. Now, Article 18 is the crucial one here, because it states that each party should be given a full opportunity to present its case. Now, a lot of debate has been engendered about the use of the word full. Some feel it means no more than reasonable. Others submitted it means something more, or it wouldn't have been there. When one looks at the travaux préparatoire of the model law, it's fair to say, I think, that reasonableness was intended to be the touchstone. The analytical commentary on the draft text of the model law provides that Section 18, quotes, adopts basic notions of fairness, and the full opportunity of presenting one's case does not entitle the party to obstruct the proceedings by dilatory tactics and, for example, present any objections, amendments, or evidence only on the eve of the award. It's clear from that passage that full opportunity to present one's case is not an unfettered right. It has to be an end to all things, including that. And now in Australia, the local arbitration acts, which are based on the model law, took out the word full opportunity and put in reasonable opportunity. And reasonable opportunity can be found in the Hong Kong Arbitration Ordinance, in the Hong Kong International Arbitration Centre rules, as well as in the Icc rules, the London Court of International Rules, and others. But as we'll see in a minute, this was not done in Singapore, whose International Arbitration Act still incorporates the wording full opportunity. But I would suggest that there can be no further argument on this topic, at least in the common law world, as a result of a seminal judgment given by the Chief Justice of Singapore, Sundaresh Menon, sitting in the Court of Appeal. Now, that case was called C CMNC against Jaguar, and it was an application to set aside an award of 3 arbitrators. And I must declare immediately that I was one of the arbitrators. Now, this case was a complicated construction case. Basically, what happened was CMNC entered into a contract with Jaguar under which they were to construct a power plant for about $450 million US. The works fell into delay. Jaguar terminated the contract and engaged others to complete the work. Following the termination, Jaguar commenced arbitral proceedings against CMNC. In 2015, the tribunal rendered its award, which it found in favor of Jaguar, and found that they'd validly terminated the contract. As a result, CMNC commenced proceedings in Singapore to set aside this award, and the court dismissed the application and they went on appeal. Now, what had happened was this. During the document production phase of the arbitration, CMNC had sought access to certain categories of documents. CMNC claimed these documents were necessary for its defense, but Jaguar objected to full disclosure of the basis that information contained in these documents was sensitive and could potentially be misused by CMNC. The tribunal firstly adopted what's called an attorney's eyes only approach. According to the tribunal's orders, the documents in question would only be disclosed to external counsel and CMNC's experts in the first instance. CMNC could then apply to the tribunal later for its employers to be given access to these documents for the purposes of giving instructions to counsel, but I don't think they ever did that. About a month later, the tribunal substituted the attorney's eyes regime with a redaction regime. Accordingly, the documents were released to CMNC's employers with sensitive information redacted. CMNC argued subsequently that the attorney's eyes only regime deprived them of an opportunity to present their case. There were other issues, but for the purposes, it was an important part of the grounds for the application to set aside was the issue I've been discussing. So in other words, they said, in the words of Article 18, they're not being given a full opportunity to do so, to present their case. Now, the judgment of Chief Justice Menon on this point is really worth reading. I highly recommend it to you. But his conclusion, with which other members of the court agreed, was that Article 18 imported only a reasonable opportunity to present a party's case, and that the use of the word full fell within that definition. That is, full meant reasonable. He too referred to the travaux preparatoires of the model law and concluded that the travaux make tolerably clear that the word full in Article 18 was not intended to create a right of unlimited scope, and, quote, that the party's right to be heard is impliedly limited by considerations of reasonableness and fairness. Now, in 2021, another case in the Court of Appeal in Singapore, CBS against CBP, followed Chief Justice Menon's rationale in the Jaguar case, but reached a different conclusion on the facts of the case. All these cases are fact sensitive. The court reaffirmed the party's right to be heard in legal proceedings is a fundamental rule of natural justice. No surprise with that. But the court then agreed that what constitutes a full opportunity will depend on the facts and circumstances of each case. And while it's true that tribunals have generally broad case management powers, they are limited by applicable rules, breach of which may lead to a serious breach of natural justice and non-enforcement of an award. Now, just the other day, a new decision of the Court of Appeal came out, and I just want to mention this. In June no, I think it's January 2021, in CAI against CAJ, the High Court in Singapore allowed an application to set aside part of an award on the ground that the tribunal failed to give the losing party an opportunity to present its case because it upheld a completely new defense only introduced in the closing submissions, which the other party had no opportunity with which to deal. And then it went to the Court of Appeal just the other day, and the court upheld a decision saying that the judge was eminently right. And both courts, of course, applied the principles laid down by the Chief Justice in CMNC against Jaguar. So that's a pretty basic due process violation. You decide your case based on something that was put in a closing submission with which the other party had no opportunity to deal. So now let me turn to how this all relates to virtual hearings. Now, during the last 18 months, most international arbitrations have been dealt with virtually. And a discussion of this topic needs to be divided between legal issues and practical issues. Now, I accept, of course, that if local law were to say that all hearings had to be in person, if requested by a party, and if so requested, that mandatory provision of local law had to be complied with, possibly with enormous consequences for one party or the other. But again, there can be some doubt about what is meant by in person. If it's said that an in-person hearing is defined as a physical hearing where both parties have the opportunity of being physically present in front of the arbitrators, that will be very clear. But if it just talks about an in-person hearing as opposed to, say, a documents-only hearing, I fail to see why a Zoom or Teams hearing would not be within that definition. I mean, there we are. I'm talking to you, and although we're not in the same room, it's difficult to say that this is not in person. You can see me, I can see you, I can see you smile or wince, as the case may be, and I can probably see you better on the screen than I could if we were in a hearing room with funny angles and funny seats. Anyhow, luckily, Icc has done some good work on this topic, and we have discovered that very few arbitral laws go as far as to demand an in-person face-to-face hearing. Icc's report indicates there's no express right to an in-person hearing in any of the 77 countries examined. However, in some countries, that right can be inferred, drawing from the principles of civil procedure law and constitutional guarantees, such as one would find in Ecuador. In some jurisdictions, such as Venezuela, a right to a physical hearing is limited to the first hearing. I'm not quite sure what the rationale for that is. The researchers did find a variance in approach among the model law countries in relation to the right of the party to request an oral hearing. While the majority of jurisdictions do not limit oral hearings to purely physical, there are some jurisdictions, especially those with an unreliable internet connection, where the right of an oral hearing could be seen as the right to a physical hearing. And finally, in several countries, including Spain, holding a remote hearing contrary to the parties' agreement could lead to the award being set aside. And in some jurisdictions like England and Singapore, it will be required to show that the violation of the parties' agreement has a material impact on the outcome of the case or substantial injustice in order to set aside the award. Now, it's important to note that the ICC rules provide that a hearing should take place if requested by a party. And the court has clarified that the right to a hearing is met by a virtual one. The new Icc Rules 2021 came into force on January 2021, and it says the arbitral tribunal may decide after consulting the parties and on the basis of the relevant facts and circumstances of the case that any hearing will be conducted by physical attendance or remotely by video conference, telephone, or other appropriate means of communication. This provision gives the tribunal the discretion to order a virtual or remote hearing if appropriate, and like the 2020 LCIA rules, strengthens the drafting with the phrase other appropriate means of communication to allow for remote hearings technology to evolve over time. And it will. I mean, the newest thing we're thinking about now is something like Zoom, but it puts everybody in the same room. I don't know how it does it, but it has some sort of camera set up. So you actually feel you're in the same room. And that will be a great advantage. And the 2021 rules, the Icc rules, no longer presume that pleadings and written communications will be submitted in hard copy in multiple sets for each party, arbitrator, and the Icc Secretariat. So we're moving over to much more electronic means of communication. Well, let's just pause for a moment and look at the benefits and disadvantages of virtual hearings. Well, obviously, it's harder to catch COVID online than it is during a physical hearing. So that's one advantage. It reduces travel, accommodation, and other associated costs. And these can be very substantial. The last major physical case I did, big one, I think we had 50 people in the room, all from different countries. We'll just add up the airfares and the hotels for that alone. It helps reduce CO2 emissions, so it's planet friendly. That can't be a bad thing in the present circumstances. It adds to the flexibility of the process and the availability of hearing dates. So if arbitrators don't have all that time flying around, they've got more time to sit around and hear cases. But there are disadvantages too. There is, of course, the risk of technological failure and other electronic disturbances. There's the confidentiality and cybersecurity issues. Some counsel find it difficult to cross-examine witnesses properly through a Zoom, and they're concerned with witness integrity and coaching. And there's a problem with time zones, to which we'll come back in a moment. And it's potential due process concerns, which at the end of the day may impact the enforceability of the award. I want to refer very briefly to some work on this topic. Tribunals, in agreeing to conduct virtual hearings, need to draft a protocol to ensure that as many problems as possible are dealt with in advance. If the protocol is agreed by the parties, it'll be harder for them to complain about it later. Now, various protocols and guidance notes have now been published by different institutions. These include the ICC's guidance note on possible measures aimed at mitigating the effects of COVID-19 pandemic, the Chartered Institute of Arbitrators guidance note on remote dispute resolution proceedings, Hong Kong International Arbitration Center's guidelines on virtual hearings, and the DLOS checklist on holding arbitration and mediation hearings in times of COVID-19. It should be noted that those guidelines do not address the situation where one or both parties object to a virtual hearing. Therefore, if the parties disagree over whether a hearing should be virtual or physical, the tribunal will need to determine the matter. My Egyptian colleague, arbitrator and academic, Mohammed Abdel Wahab, W-A-H-A-B, has suggested an approach based on the applicable law and governing procedural rules in such situations, and he considers 4 different separate scenarios. Firstly, whether law or rules expressly refer to the need for an in-person physical hearing. 2, where they expressly refer to the possibility of virtual hearings or use of technology. 3, where they are silent on the issue and no inferences can be drawn. And 4, where the law and rules are inconsistent. And I recommend his paper on this topic, which you can find in the Global Arbitration Review, What If the Parties Don't Agree, Virtual Hearing, Pandemic Pathway. It's worth a read. It's quite interesting. Now, subject to what I'm going to say next, my personal view is that very few courts would conclude that there was a due process violation by virtue only of a hearing being virtual. Now, I now turn to deal with the important topic of practicalities. It's always helpful to test a theory by subjecting it to practicalities. So let's take an extreme case. The tribunal orders a virtual hearing against the wishes of the respondent. The claimant and its lawyers are based in a country with perfect internet, if there is such a thing. The respondent and its lawyers, on the other hand, come from a country with poor and intermittent internet. All the members of the tribunal have excellent internet. The claimant's submissions and evidence come over clearly to the tribunal, but unfortunately not to the respondents and its legal team, which only receive a very scratchy picture, intermittent sound, and a lot of, what's it called, buffering or something, when it stops and then starts again. The claimant wins, and the respondent concludes that due to the quality of the internet, it was unable to present its case. At any rate, its case was not presented clearly, in contradistinction to the claimant's case. The respondent feels that part of its evidence was not properly heard or appreciated due to these defects. Now, in this situation, provided the facts that I've set out were sufficiently established, I would expect most courts to have sympathy with the respondent's predicament, and the award may well find itself not enforced. Another problem that can arise, which can provide due process allegations, is the actual setup of the virtual hearing as ordered by the tribunal. Let me give you an example. The claimant and its legal team are based in Hong Kong. The respondent and its legal team are based in India. The claimant's arbitrator is in Hong Kong, and the respondent's arbitrator is in India, and the presiding arbitrator is in Hong Kong. The claimant and the 2 arbitrators sit at HKIAC. The respondent and 1 arbitrator sit somewhere in Delhi. The hearing is virtual, as between Hong Kong and Delhi. Now, in my view, it would have been unwise for the tribunal to set up a hearing in this way, unless it was agreed by the parties. The respondent would have been entitled to have concerns that the opposing party's arbitrator and the presiding arbitrator were together in the same room, whereas its arbitrator was in Delhi. I think that would be an unfortunate situation. But if the respondent did not object to this in advance, can it be allowed to complain after it finds that the award has gone against it? Probably not. And that's the importance of having an agreed protocol. But what if the parties agree to a virtual hearing, but on the day, the internet performance was substandard? What would happen if one party was more disadvantaged than the other? What if one party and their counsel are in Delhi, while the other is in New York, and the arbitrators are in Hong Kong? The time difference between Hong Kong and New York is 12 hours. In case of a complicated dispute, hearings might take weeks. The party in India will definitely benefit from the time zone differences. Does it count as a disadvantage that the party in New York was forced to argue their case at very awkward hours for them? And this is interesting because take Australia, for example. Australia had a great difficulty in making itself very popular as a venue because of the tyranny of distance. Now most things are done on Zoom or Teams. The tyranny of distance has given way to the tyranny of time zones. I can tell you I've done a BIT case as chair where I started at 5 a.m. in the morning and finished at 8 a.m. in the morning. And I didn't mind that. We did that for 10 days. So we got 30 hours. And that was the only way we could do it. So I was finished work by breakfast, which is not a bad thing to do. So having discussed what I've said so far, I think it's time to look at how national courts have responded to due process concerns of the aggrieved party. And I've got a few cases from around the world here we can look at. The first is the Swiss Supreme Court in June 2021. They found that an arbitral tribunal had not violated the plaintiff's right to be heard by rejecting their request to postpone the hearing. After initially agreeing to a video conference hearing, the defendant, a day before the scheduled video, changed its mind and requested a face-to-face hearing rather than a video, and requested postponement for 3 months, given the difficulties inherent in the COVID crisis. On the day of the hearing, the next day, the defendant's lawyer asked the tribunal to postpone for at least another month. The tribunal rejected the request, referring to the duty to avoid unnecessary delay, which was in the LCIA rules, and maintained the remote hearing. The court upheld the award, rejected the appellant's arguments. In the court's view, the appellant had not established that they were actually prevented from filing a response and witness statements. They had not explained either what kept them from coming forward and exposing their alleged difficulties when the tribunal called on them. Moreover, in their appeal, they're not sought in any way to demonstrate what evidence, arguments of fact or law they could have presented if they'd benefited from a postponement requested to supposedly prepare usefully their defense. The appellant's silence on the last point only reinforced the court's conviction that the difficulties in finding a lawyer and gathering evidence amid COVID was only a pretext. Now, the Austrian Supreme Court looked at this too. There was an arbitration in Vienna administered by the Vienna International Arbitration Center, VIAC, and they challenged the arbitral decision tribunal over its decision to conduct an evidentiary hearing by video conference. After VIAC rejected the challenge, the case went to the Supreme Court, and the court held that the arbitrator challenges based on allegations of procedural irregularity can only succeed under Austrian law if the tribunal's conduct of the proceedings were to result in serious procedural violations or in permanent and significant disadvantage to a party. And the court found that holding a remote hearing against the objection of a party does not meet that threshold. One of the issues raised before the court was the start time was changed to 3 o'clock Vienna time. And as the Respondents' Counsel and one of their witnesses had to be examined in Los Angeles, this placed the beginning of the hearing at 6 a.m. local time. So the respondent claimed they're not being given an opportunity or appropriate notice to prepare for the hearing. They argued the decision to start the hearing at 3 Vienna time, the time zone of the claimants, and 6 a.m. Los Angeles time, the respondent's time zone, amounted to an unequal treatment of the parties. And they said that a remote hearing amounted to a violation of the duty to treat the parties equally and fairly. Anyhow, the court expressly confirmed that as a general rule, remote arbitration hearings are not only permissible if both parties agree, but even over the objection of one of the parties. For this, the court relied on Article 6 of the European Court of Convention on Human Rights. Article 6 provides the right to get effective justice, to give effective justice and be heard. Now, I'll come back to that because there's some cases from the European Court on this thing. On the time zone issue, which comes up regularly in these cases, the court considered that the difference between Vienna and Los Angeles meant the hearing could not take place during the core business hours for all the participants. And they said that by for VIAC, an institution based in Vienna, the respondents had in principle accepted the disadvantages resulting from geographical distance to the place of business, including travel and time differences. And the court found that disadvantages were not exacerbated by a remote hearing. And au contraire, they said the court took the view that starting at 6 a.m. local time was less burdensome than having to travel to Los Angeles, from Los Angeles to Vienna for an in-person hearing and go back again. And so I think there's a lot of support there. They then dealt with the argument about witness tampering. Now, this argument about witness tampering has come up for years because although we're talking about virtual hearings as if it's all brand new, it's not, because we've been using video conferencing for witnesses who couldn't attend for one reason or another for a long, long time. And in fact, during the SARS pandemic, I conducted the whole case remotely. And that was 20 years ago. I was the only one in London. Everybody else was in Hong Kong. We managed to do it then. Now, the question of witness tampering, if you've got somebody in a room giving evidence, there's always the fear that there's somebody behind the camera telling him what to say, holding up signs, don't answer this. I mean, this is pretty fanciful because, first of all, you can have cameras wherever you like. Secondly, if you're really worried, you can have an independent lawyer sit in the room and report back if there's anything untoward happening. So I think this whole idea about witness tampering is a red herring because you could tamper with the witness, before they go on screen. So anyhow, so they dealt with this and they said that there are many ways around it. Some of the ones I've given, you can record it, you can make the person show their hands so they're not reading something. You can have a camera showing exactly where they're sitting, and you could have somebody present. So I think that's a red herring. Now let's have a look at the European Court of Human Rights. There are a number of cases that touch upon the issue of virtual hearings in the light of due process safeguards listed in Article 6. And the court summed this up this way: this form of participation in proceedings is not as such incompatible with the notion of a fair and public hearing, but it must be ensured that the applicant is able to follow the proceedings and to be heard without technical impediments. Now, I must say, the court has not yet opined on any case involving arbitration and due virtual hearings. But the overall position of the court may be described as follows: virtual hearings are not contrary to Article 6. Due process complaints about virtual hearings must be examined case by case. We've seen that already. The following issues are to be taken into account when considering a potential breach of due process in the light of a virtual hearing. 1, is it valid under law, the state laws, to have a remote hearing? 2, was there a good reason to hold a video hearing rather than a physical one? Was it proportional? 3, Was a person given an opportunity to participate? Was he represented by lawyers? 4, whether technical problems impacted on the audio-visual aspect of the hearing. 5, whether it was technically possible for the accused to communicate with his lawyers confidentially should also be taken into account. And at least in one case, Shulipov against Russia in 2008, the court highlighted that it was a certain disadvantage that the applicant appeared before the court by video conference while the prosecutor appeared in the courtroom in person. So you're getting back to the sort of example I gave before. But how many of you do you think would say that this reasoning can be applied to arbitration proceedings, where one party is represented by counsel physically before the tribunal, while the other party appears by Zoom? I think in the criminal context, the fact that a defendant is miles away in a prison with a video link, maybe without his counsel present, whereas the prosecutor and their team are all in front of the judge, is a pretty unfair situation if something serious is going to be decided. But that's a matter, of course, for state courts. Now, there are a few more cases. There's the Consortio Reeve against Briggs of Cancun, a decision of the United States District Court, 2001. And just to sum that up, the court held the respondent could have presented its case by using other means to participate, such as by sending a company representative or an attorney to attend the hearing. The court held that the respondent did in fact participate by designating its arbitrator and filing 80 pages of legal argument in support of its position early in the proceedings. So there they didn't turn up, but the court found they had actually participated or could have participated. So nothing, that was not set aside. Landesbank Baden-Württemberg, Icc Administrative Council refused an application by Spain to disqualify Tribunal on the basis that its decision to hold a virtual hearing in the midst of the pandemic lacked impartiality and the high moral character required under Icc Convention. And the council observed this: given the extraordinary circumstances and the multiple uncertainties created by COVID, the tribunal's decision to conduct a risk assessment certainly does not show a lack of high moral character. Rather, in the eyes of an objective third party, it would appear to be the tribunal's duty to do so. A party's disagreement with the tribunal's risk assessment is no basis to conclude there was a manifest lack of the qualities required by paragraph 1, article 14, to disqualify the tribunal. So, how do we sum this up? In relation to due process paranoia, I think we can agree with Lucy Reed in her article I referred to at the beginning, namely that routine arbitral process in all its details should not be conflated with a small subset of procedural decisions that implicate due process. The due process is the foundation of the legitimacy of binding dispute resolution processes, including international arbitration. And when due process is invoked frivolously or cynically, it cheapens, if not threatens, this foundational principle. And an arbitral tribunal is both the manager of routine process and, more importantly, the guardian of due process. So in relation to virtual hearings, as it can be seen, they have their own benefits and shortcomings. And while it's apparent that the Icc survey that there is a worldwide trend that there's no express right to an in-person hearing, it's always important to check the applicable laws and governing procedural rules to be on the safe side. And following the decision in Jaguar, as well as some other cases, it's clear that a party should always be given a reasonable opportunity to present their case. What is reasonable should be decided on a case-by-case basis, but it doesn't mean that they should be given an unreasonable opportunity of presenting their case. And it's also apparent that in most situations, the right of a party to present its case would not be infringed by the adoption of virtual hearings. However, it does not mean that some matters incidental to this type of hearings, like technology failures or time zone hardships, may have an impact. It's also evident that virtual hearings are here to stay. Having said that, according to the Berkeley Research Group 2021, it's not expected to become a worldwide new normal because, according to this report, 90%, up to 90% of hearings are expected to be conducted entirely in person across the next 12 months in the United States. In the UK, up to 70% of domestic arbitrations could completely return to face-to-face settings, with 20% hybrid and 10% entirely remote. However, in Asia, only 5 to 25% of hearings are expected to return to person. Without
Mr. Kaplan, I think you're stuck. Your screen's frozen. Yeah, I think his internet is a little unstable. We can't hear you properly.
to remain fully remote.
Mr. Kaplan, we can't hear
over
you
the
properly. I think your internet connection is a little iffy.
12.
We'll just wait for him to log back on. Yuri, if I'm saying your name correctly, is there a way to contact Mr. Kaplan?
Let me try, give me a second.
Yeah, thank you. Please stick around. We're trying to exactly, yeah, Giuseppe. Yeah, we've been talking about virtual hearings, and Mr. Kaplan mentioned poor internet. He's in the UK and he's sitting in London, and apparently it's poor internet. So let's just give him some time, and I'm sure he'll be back. I'm really sorry this is happening. I'm just going to figure out what's going on.
Okay, we have an issue with the computer there, so we're working on this. I think it should be okay in a couple of minutes.
All right. Thank you. Thank you so much. We'll just wait then. Thank you.
Okay, we have a suggestion because the computer unfortunately doesn't work properly. I will try right now to connect Neil through my computer by basically using my mobile phone. Not sure about I'm not sure about the quality, but let's at least try to see whether or not it's gonna work.
Yes, let's try. Let's try.
So, Neil, could you please talk?
Can you hear me now?
Yes, we could hear, but there's a lot of feedback. So everyone, please put yourself on. Yuri, we could do it like a podcast and everyone else could be on mute, but we can't hear Mr. Kaplan yet.
He's not talking right now.
Okay, he can start if your connection is stable.
Wait a second.
I don't understand why. Plugged in. How do I know they can hear?
Now you can try to speak and we will see.
Okay. Well, the last thing I remember saying was that only 5 to 25% of hearings are expected to return to in-person hearings in Asia. And as I said, that's not surprising because of the non-COVID policies of China. So what we've seen is that virtual hearings have their own benefits. There's a market demand for in-person hearings, at least in the UK and the US. Will we go back to pre-COVID times? I don't think we will. We will still use Zoom and other platforms for use for interlocutory hearings and arguments on pure issues of law. But we will go back to hearings where there are witnesses, particularly when there are expert witnesses and where the evidence is technical. I'm quite sure that will happen, and it is happening. Can you just check that? Can someone let me know that you can hear me?
They hear you, they hear you.
Okay. So I want to end by reminding you all that you're the next generation of dispute resolution lawyers, and a heavy burden rests on your shoulders. The present system is not perfect and can be improved, and advances in technology will also cause us to rethink the way we do things. Only a week ago, the Chief Justice of Singapore delivered the Gough Lecture in Hong Kong, and the title was dramatic. It was The Complexification of Disputes in the Digital Age. And he pointed out that however far we've got technologically so far, it will speed up enormously in the next few years. And he pointed out, as an example, in 1999, the whole of the internet for that year used 1.5 gigabyte of data. Today, that amount of data is used every 18 hours. And by 2025, that amount of data will be used every 5 hours. Sorry, every 5 minutes. So it's your generation that's going to have to find a way of handling this problem. But before you can do that, you have to identify and be aware of the problem. The Chief Justice refers to evidential complexity, and by this refers to the sheer volume of material that is currently thrown at judges and tribunals. And Lucy Reed again reminded us some years ago that it's not a question of what you can get into an arbitrator or judge's head, but how much you can keep there. Submissions have become far too long. Discovery has got out of hand. Applying a cost-benefit analysis to the time and money spent on it, it would be found to be inefficient and unnecessary. You need to be more proactive in drafting the arbitration clause. The arbitration clause is the last opportunity you have of coming to an agreement with your other party, because once hostilities break out, you won't be able to agree anything. So put things into your arbitration agreement that help to keep costs down and the proceedings more speedy. Think out of the box. Don't forget about mediation. Don't forget about dispute review boards. Be innovative with bifurcation. And be prepared to work with experienced tribunals to fashion a suitable procedure for the case at hand. Don't be resistant to the use of early openings, which are a good way for the tribunal to prepare their case. They have the case opened in advance of the main hearing, and this is very important. And we've seen, I think, as a corollary to these problems, enormously long awards. If you take every point in sight, both good and bad, it's inevitable that the tribunal will have to deal with them all, and this will take time and expense. And it's time and expense that is the main complaint leveled against the system. Now, I can hear some of you saying, well, what can we do? We're only law students. Well, I hope that some of you will soon be assisting arbitrators as assistants or tribunal secretaries. And in those roles, you can begin to assist. If you help an arbitrator draft parts of an award, avoid the kitchen sink approach and learn to summarize or précis the argument. When your counsel, concentrate on the good points and abandon the bad. The art of advocacy is the art of persuasion, and you do not persuade by boring or overwhelming your tribunal. A good point does not improve by being repeated time and time again, or by being surrounded by several bad points. Make it stand out. And then when you're senior, you can put these best practices into operation. Many years later, you will make a better judge or a better arbitrator. So please learn from the mistakes of the past and do not, I beg of you, emulate them. Thank you very much. Was that heard?
Yes, perfect. Thank you. Thank you so much. Is there a way in which maybe we can take questions for 10 minutes? Can Mr. Kaplan hear us?
Yeah.
All right. So maybe this was great. And thank you so much for the advice at the end. Maybe whoever is around, we do have more than 20 people who are on the chat right now and didn't drop out in spite of the hassles. So maybe you can use the raise hand function or type out your questions in the chat box and I'll relay it. Does anyone have any questions, observations? Please do ask your questions. This is your opportunity. Yes, Aditi. Why don't you unmute yourself?
Yes, Professor. So my question was with respect to the statistics regarding the in-person hearings. So I think Professor had stated that about 90% of the cases in the US will resort to in-person and 70% in the UK. while in the case of Asia, only 5 to 10% of the cases would return to in-person or physical hearings. So what do you think are the major reasons for the statistics?
Well, I think I gave one of them, and that is that, China is a very big part of Asia, and Hong Kong and China have a lot of arbitration cases together, and you have to quarantine. And who's going to go there if you have to do 21 days quarantine? I won't, and many other people won't. So we're doing hearings remotely. I can't think of any other reason why that is so, other than the fact that China has this no zero COVID policy. But I'm now in London, and I went to the International Arbitration Centre here by St Paul's Cathedral, and it was very busy the other day. You wouldn't know anything was going on in London apart from a few people wearing a mask. And the same, I think, is happening in America. So I think there may be just different tolerances to risk as well. I can't give you any more answer to that question, I'm afraid, than what I've already said.
Right. Aditi, does that answer your question?
Yes, sir. Thank you very much.
Right. Giuseppe, please go ahead.
Yes, thank you, Akansha, and thank you, Mr. Kaplan, for your insightful talk. I just had a question. So you mentioned since virtual hearing might increment problems related to confidentiality, but also cybersecurity or technical failure. Just focusing on cybersecurity, what would be sort of best practice or any advice that could be useful to minimize, leaking information and so forth, especially, in very sensitive cases? Thank you.
Well, this is not really something that arbitrators are big state to deal with. I think all we can do as arbitrators is to make sure that the parties are aware, as I'm sure they are, of cybersecurity problems, and that they should put in place, appropriate checks and balances. So, for instance, when you're dealing with documents, all being shared, you have a very complex system with passwords and encryption, so that people can't dig in and get hold of these documents. And then, of course, you've got the rules and regulations about data information. And again, that's something that arbitrators are wise to put on the parties and make it a procedural order that says that the parties shall comply with all rules and regulations that deal with privacy and confidentiality. Because you know what, the GDPR regulations that apply in Europe, and there's no way an arbitrator can deal with them. The parties have got to come up with a protocol to make sure everything is safe. There's some basic things you've got to be careful of. Going airports, when you turn your computer on in an airport, you're slightly at risk. In some hotels, you're at risk. So you should have some form of protection on your computer. And I think you've got to be very wary of any arbitrator or counsel in arbitration who's got just a simple Gmail address.
Thank you.
Right, thank you. James?
Thank you. I just have a very quick question, Prof. Kaplan. Thank you very much for the very interesting insights about this virtual hearing. I just want to ask, in terms of the costs, it has been stated that many say that this probably with virtual hearing, then you can save up a lot of cost in terms of traveling and accommodation. But what about the fact of using a lot of, I guess in virtual hearings, you also need to consider using transcribers or also some third-party providers for e-documents to ensure that documents used for evidence can be displayed effectively during the proceedings. So how do you see this play into the picture? Will it really make the cost cheaper for virtual hearing?
And if I may add to that question a little bit, because I had a very similar question, that there are, yes, costs involved with the platform, transcription, etc. How does one also, as an arbitral institution offering virtual arbitration, concerned about due process issues, balance the concerns of speed and cost effectiveness in the virtual arbitration also? Won't an online arbitration maybe somewhat tempt the tribunal into taking shortcuts in an online system? And then where does one strike that balance in ensuring due process concerns being taken adequate consideration of alongside costs that may be associated with online hearings? Thank you.
Well, I heard the first question from the gentleman. The second question wasn't quite so clear. It didn't come over very clear on my phone. So let me just deal with the first one. Whether it's a virtual hearing or whether it's a hearing in person, you still have the cost of the online registry of the documents, because today we put all the documents in a particular provider, and they bring them up, and we can get them encrypted, and then we can get them up safely on our screens, and then they're put on the screen at the main hearing. So that applies whether you're in person or not. There will be a few extra costs, I suppose, of arranging a virtual hearing, but it's infinitesimal compared to the cost of renting a room, having all the equipment in the room, having the document providers in the room, and everybody flying there. It's a no-brainer, I think, when it comes to costs. So, can somebody just remind me or clarify the second question?
Right.
Maybe.
So the second question was more in relation to whether the due process concerns and the principles in the online space are, let me put it more differently, more flexible than the concerns of due process in the physical space. Because while you do have costs of the online platform, most online platforms costs are on time basis, and therefore you just might, as a tribunal using a third-party online platform, be tempted to start taking shortcuts. So where does a tribunal or an institution offering virtual arbitration services strike that balance between due process concerns being addressed as well as maintaining the cost effectiveness and the speed of online proceedings?
Yeah. And what do you mean then? Let me ask you a question. What do you mean by taking shortcuts? Explain that.
For example, let's say a party doesn't appear, for example, you mentioned internet issues and they have continued internet issues. Could an arbitral tribunal then, after say 2 opportunities or 3 opportunities, take a judgment call because there are costs associated with the online platform, and then go ahead ex parte because opportunity was given? That's the kind of shortcut I meant. That you did give an opportunity, but because the online proceedings have a cost and there is another party that may still continue to not appear, where does that balance get struck in the online system?
Well, again, forgive me, but between your phone and my phone, it's not coming over very clearly. But I think what the issue is, you shouldn't take shortcuts. You should never take shortcuts. And I mean, if you're positing that one party's internet is not very effective, and the tribunal go ahead anyhow, and listen to the other side, the internet is better, that's clearly not right. But I'm sorry, but I'm not really following the question properly.
No, it's okay. That answers the question. That answers the question.
a minute. Hang on a minute. Hang on a minute. My computer's come back to life again. So I might be able to log on and I might be able to see you. And that might make things a lot easier. Hang on. Trust in technology. No. He's going to take it also. You were saying something.
That was you can repeat. Let me unmute myself. Yeah. Talk.
I was going to ask a shorter question.
The question basically was that using the online platform, and sometimes for the online platforms you need to pay. And let's say we have a party with, all the experts and everybody, let's say, in the room, and they want to have the proper oral hearing, and the other party cannot connect because the issues of the internet. And is it possible for the arbitral tribunal just to make a shortcut and say, look, we gave you, let's say, not for a number of days, we gave you opportunity to take a part in the proceedings. You're complaining about the internet. We cannot just sit and wait indefinitely for you to get the proper internet. We continue this on the ex parte basis or something to that extent. And we are sorry we gave you opportunity.
Okay. The answer is no. It would be totally wrong to do that. And I can't imagine a tribunal doing that. Look, my internet's broken down today. If this was a case, we would have to go back another day and carry on for where we left off. You can't just say, well, let's ignore it now, let's carry on. It's like somebody got locked in the toilet and couldn't come out to give evidence. You wouldn't just go on in their absence. You'd get the door open.
Right.
Crude example, but you see what I'm getting at. Anyhow.
But Neil, what about the situation where one party just cannot take part in the proceedings? Let's say they, in some country where you basically have no interest, some African country, let's presume somewhere like a Chad or something, or Somalia, just giving up from my head.
Don't mention any names.
Okay, some identified country somewhere.
Yeah. I got the point. Well, I'm sorry, if they can't have internet, then you can't have a virtual hearing. You just have to find some other way of dealing with it. You either travel to somewhere that has got a decent internet that's nearby, or you have to find a way of having
documents only
at a time when it's safe to do so.
Right. Understood.
And you can't travel, and you can't do it on the telephone, then you're stuck. There's nothing you can do. You can't go ex parte in those circumstances.
Right. All right. Thank you so much. Are there any more questions, or else we'll close the session because of time slot? Any more questions? Anyone? Any observations? Anything? If not, thank you so much. And thank you, Yuri. I hope I'm saying your name correctly, for helping facilitate this. Thank you, Mr. Kaplan. I hope you can hear me. Thank you for making an effort to still finish this talk with us. We do hope to have you back at JGLS in better internet circumstances, and hopefully when travel is permitted, we can host you in person here. Thank you, everyone. Thank you once again. Have a good evening and have a good rest of the day, Mr. Kaplan. Bye-bye.
Thank you. Bye.